Morning, everybody.
Good morning, everyone. Good morning, Judge Rovner. I can see you way over there to the right, but I can't see you here in front of us.
Oh dear.
The monitor must be off.
Okay, monitor, get to it.
Good morning, Judge Rovner.
I must be seen. I put makeup on this morning.
As it's the highlight of my day, so you have to be seen in front of us here.
Exactly. Uh-oh. Uh-oh. If
There we
that's
go.
the highlight, we're in big trouble.
No, it's true. It's true.
Oh, it's so great to see you all.
Yeah, it's always a
as
pleasure
well.
to see you.
And let me just tell everyone in the courtroom that Judge Brennan and Judge Kirsch and I are very happy you're here today. And we're going to call the first case. And that is 232512 Damona Freeman versus Ocwen Loan Servicing. And good morning, Mr. Wooten.
Good morning, Your Honor.
You may begin any time that you are comfortable.
Thank you, Your Honor, members of the panel, my colleagues. Let me begin by setting the framework of this case. This case is about a recidivist debt collector who instituted a foreclosure on a consumer who was not even in default. The consumer was required to hire a counsel who had to defend the foreclosure, and all of that occurred prior to filing the suit in this case. Without counsel's intervention, based on its normal operating procedures, Ocwen would have taken Damona Freeman's home because that's how their processes worked without intervention of counsel. Now, in addition to those issues, she also received the other things that we've heard a lot of cases about out of this court lately: letters that were wrong, calls that were unwanted, door knocks, messages, communications that were false. But at the end of the day, without the intervention of counsel, she would have lost her home. So her injury is not trivial, fleeting, insignificant, or unrecognized by any law, statutory or common. And
Mr.
Yes,
Wooten,
ma'am.
may I start you, please?
Yes, ma'am.
What was happening between June of 2018, when Ocwen first called Freeman and erroneously told her she was in default of her mortgage loan, and October 31st, when Freeman filed an answer and counterclaim to the Bank of New York's second foreclosure case? Was anyone trying to point out Ocwen's error and correct it?
Yes, ma'am. And I meant to warn Judge Brennan that he might feel deja vu when he heard this argument today, because he was on my panel 5 years ago in the Sacramento case that covered the exact same conduct post-jury verdict. So yes, ma'am, Ms. Freeman was communicating, trying to communicate. Ocwen's testimony on the point was that they had bungled a bankruptcy reconciliation, something they were obligated to do correctly under a consent decree with the federal government. And they did that, and it caused them to declare her loan to be in default, and it caused them to institute foreclosure, and it caused them to demand payment from her of thousands
But
of dollars.
I'm going to stop you for a second,
Yes, ma'am.
because did she dispute the inaccurate information in her credit report by submitting a dispute to a consumer reporting agency?
Yes, ma'am. If you'd like to talk about that point, let me make this, I think, a very important point that the appellee has tried to cloud. The term dispute has a very specific meaning under the FCRA. The term dispute encompasses a consumer notifying a credit reporting agency. The FCRA defines when a consumer contacts the furnisher as a direct dispute, and that is a statutorily defined term. I believe the site is 10 CFR 1022.43. But when a consumer or the law on the FCRA uses the term dispute, it encompasses contact with the CRA to trigger the S2B rights of the consumer. And we've attached one term.
Which consumer reporting agency did she submit the dispute to? And we're talking about, between June 2018 and October 31st.
There is a dispute noted in the record at AA 239 in the appendix, Your Honor. And I believe that credit bureau was Equifax, and I believe they required a response during the month of October of 2018.
And is there evidence that the credit reporting agency sent a notice of the dispute to Ocwen within 5 days?
Yes, ma'am. This document came from Ocwen.
Within 5 days?
Yes, ma'am.
Where is that evidence?
It's AA 0239 in the appendix.
And what is the evidence that Ocwen failed to conduct a reasonable investigation?
Your Honor, you can read Ocwen's own judicial admissions at pages 6 through 8 of their brief, where they discuss the course of events with their request for information, where when they actually, under the RESPA obligations that Mr. Core invoked, they actually went and investigated the accuracy of their accounting, they readily and easily discovered their error. So the fact that they did not readily and easily discover their error as part of their credit reporting investigation leads to a very easy inference that they did a poor to non-existent reinvestigation.
You may continue.
Okay. With respect to the concrete injury analysis, Congress in its wisdom recognized that the FDCPA was crafted to prevent abusive debt collection. And Congress in its findings set out a number of injuries that consumers suffered because of abusive debt collection that were real and substantial and tangible. This is a classic example of the type of real, substantial, life-altering change that can come from abusive debt collection. Ms. Freeman's lived under a cloud from this event now for 6 years, and it is not resolved.
Would you agree that Ocwen's duty to investigate would only arise after the CRA informs it of the dispute, not when the consumer disputes directly to Ocwen? Would you agree?
Yes, ma'am. Under the FCRA, Ocwen has no duties which Ms. Freeman can enforce unless she makes a dispute through a CRA, which is what she did, despite Ocwen's attempt to muddy those waters. Ocwen made the challenge to the complaint on that grounds, holding documents of its own that it had provided to my counsel colleague, saying that they had received the notice and they had the opportunity to respond.
I guess I should explain my problem.
Yes, ma'am.
I did not see that Ms. Freeman alleged that she disputed the credit information with any CRA. What she alleged was, and I'm going to quote, "On information and belief, Ocwen has improperly and incorrectly reported to various CRAs that the loan was and or is 90 to 119 days late, period."
Yes, ma'am.
And I'm not certain that that's a sufficient allegation, because what she should have alleged, it seems to me, is that she reported the dispute to the CRA, not to the lender or servicer, and then that Ocwen received notice of the underlying dispute from the CRA, because Ocwen's duty to investigate only arises after the CRA informs it of the dispute, as I mentioned, not when the consumer disputes directly to Ocwen. So you help me with that.
Yes, ma'am. Ms. Freeman never made a dispute to Ocwen. That would be what the law calls a direct dispute. That did not occur. The disputes were made to the CRAs. And at the time Ocwen filed this motion to dismiss, they already held records, which they'd provided to my colleague, saying they had received those disputes. So their obligation was triggered statutorily. And in our record, we pointed to at AA 0239, at least one instance that's in this appendix where they had a dispute to Equifax about this account before Mr. Corrin filed suit in December of 2018. Despite having that information and despite knowing they had received those disputes, they've come to this court and tried to muddy the waters and say that the complaint says we disputed with Ocwen. Disputes only occur under the FCRA to a CRA. When you dispute to the person who reported, the CRA's, the credit reporting law calls that a direct dispute. And we never once have alleged that we made a direct dispute because that's not actionable under the FCRA. So what Ocwen has asked for, Your Honor, and it's our concern, and bear in mind, we were not at summary judgment with the FCRA claim. We were dismissed on a motion to dismiss, and we were not given a chance to amend that claim. If Judge Pratt had asked us to correct, to say which CRA and what date, the heightened obligations under Rule 9, we could have done that. We were not given the opportunity.
Mr. Wooten, in the last 5 years, there's been a lot of law that's been issued with regard to standing.
Yes, ma'am. Yes, sir.
Specifically, the case presents 3 intangible potential injuries and 1 tangible injury. Among the intangible injuries, there's been alleged the defamation, false light, the intrusion upon seclusion, and the third one as well, with regard to abuse of process. Among those 3, just talking about the intangible, what is your client's best argument?
Obviously, if you want to take someone's house when they're not in default, that's a pretty big one. Mm-hmm. So I would think in this particular circumstance, while we talked about abuse of process, wrongful litigation, that's also a trespass, a title and a trespass, even though we didn't argue that, I understand. But yes, whenever you're trying to take someone's home and they're actually paid 3 months ahead, it's kind of a problem.
So the third of the 3 intangibles you believe is your strongest?
Yes, sir, but we think they all qualify, and we think the conduct that she was exposed to in the interim constitutes what we've also known as assault, because there was unwanted communications that put her in fear of harm, but didn't rise to the level of a battery because there was no physical contact, right? But definitely the invasion of privacy, intrusion upon seclusion, and false light. Because under the FDCPA also, the inaccurate credit reporting is actionable even without any dispute whatsoever. And that's part of the trick in this case is it's easy to cross the wires among the 2 statutes and the requirements, but the FDCPA requires nothing but the false publication, or a failure to note it as disputed. But in this instance...
Oh, I'm sorry. Please finish your thought. I'm so sorry.
No, I apologize. I wanted to reserve some time. I'll stand here all day if you'll let me.
Okay, fine. No, I am going to give you that time because we're asking you questions. But I did want to just mention something. The district court granted 2 requests to amend and and then denied the third because it occurred outside of the deadline. So, I think we need to,
I'd like to cover that ground,
Sure.
if you'll hear me on that, Your Honor. So the 2 amendments were made in the nature of supplementing additional factual allegations related to post-litigation conduct, so conduct that occurred beyond the filing of the case in December of 2018. The one thing that never changed was the FCRA complaint. And that was actually answered twice. I mean, answer, as in no motion, filed an answer twice. And then when we restated the complaint on the Second Amendment, then they came in and said, you didn't tell us which consumer credit reporting agency you reported to or you disputed to. You didn't give us enough detail. At the time, they're holding the disputes in their hand and know exactly what they are. So it's a technical case of gotcha, not a lack of notice about what had occurred.
But it seems that, and you tell me if I'm wrong, it seems that no good cause for needing to amend was given other than that she wanted to, quote, fix any deficiencies. Is that incorrect? And in the motion for reconsideration, according to the court, you did not identify how she would fix the deficiencies in the Second Amendment complaint if you were granted leave to amend outside of the deadline.
Well, yes, Your Honor. Let me say this. There was no analysis under Seventh Circuit precedent about whether an amendment should be allowed. It was sort of a summary comment that because it's beyond the deadline, I'm not allowing it, and you didn't give us good reason in your motion to reconsider. But the motion to reconsider pointed out that the record already contained evidence showing that Ocwen had received disputes through a CRA even when they made the challenge on the complaint. So, again, the way, and we've cited cases about how the FCRA works, and the Seventh Circuit has never required us to allege that the furnisher, that the CRA did its job under the law. We've always been allowed to presume that if we file the dispute with the CRA, that they do, in fact, carry out their legal obligation and provide it to the furnisher. And we cited numerous cases for that proposal. It started with the unpublished case of Lang, but there's at least 2 cases beyond Lang that rely upon Lang that are published from the district courts. And so, in essence, we got gotcha'd by a defendant that knew that it had received disputes. And so when Judge Pratt made the decision to toss the count on the technical content, she did not allow us the opportunity to address that. Had she done so, we could have laid out each of the disputes that we had from those records at that point and explained that to the court in great detail. And I apologize, I've gone over my time, but I'm happy to answer any other questions.
Don't you worry. Do either of you have any other questions? Nope. Okay.
Thank you.
Okay. You'll get your 3 minutes.
Thank you.
Mr. Lynch, please.
May it please the court, my name's John Lynch. It's my first opportunity to argue in the Seventh Circuit, so I'm very pleased to be here.
Welcome.
I'm representing the Apple.
We're happy. We're very happy. We love it when we have new people.
Well, thank you. Thank you very much. And I represent the Applees, Ocwen, and Boney. There is no appeal being taken against Boney, so the 2 issues are against Ocwen. One is the motion to dismiss on the FCRA claim. The other is the summary judgment on the standing issue on the fair debt. If it's okay with the court, I would start with the FCRA claim.
Mr. Lynch, can I ask you a question about that one? It seems to me that Mr. Wooten is arguing. I have the exact same questions that Judge Rovner has, okay, but I want to ask him a little different way. I don't see anywhere in the complaint where the plaintiff alleged that they notified one or more of the consumer reporting agencies. I don't see that in the complaint. But it seems to me that Mr. Wooten is arguing today that it doesn't have to be a direct notification to the CRA, that he can do something else or that she can do something else to dispute the accuracy of the credit report. Can you respond to that argument?
Yes. So under FCRA, there's 4 elements. And there's no allegations of the 2nd, 3rd, and 4th element in paragraphs 41 through 55 or 278 through 281 in the second amended complaint. That is a required element, that you dispute the inaccurate information by submitting a dispute to a CRA. Mr. Wooten has said that, oh, we're hiding the ball. They know, the plaintiff knows and has the burden to allege if they submitted a dispute to the CRAs. They did it. They have that information. There's no allegation in the complaint of that element whatsoever. Then the next element, Judge, is the CRA transmitted a notice of the dispute to the furnisher within 5 days of the receipt by the CRA.
Hold on, that would be hard for her to allege in a complaint. I mean, I may be with you on the first argument that you have to make a notice or dispute to the CRA, but I don't know how she could allege it, but based on what?
You typically, plaintiffs all over the country get that information from the CRA. Typically.
But let's say they didn't. Let's say they didn't do that. Would that not still be a violation of the law?
If that didn't occur, that would be a violation of the law. One thing I point out on that particular element is Mr. Wooten and the plaintiffs say that that's attached to the complaint, but they never reference it in an allegation or say what the ACDV said between Equifax or one of the CRAs and Ocwen.
Right, you can't plead by attachment.
You can't plead by attachment.
It'd be impossible for a judge to go through hundreds of pages
So
potentially of attachments.
we believe that's waived for a couple reasons. They attach the documents. They don't plead it or reference it at all. They also don't make that argument in opposition to the motion to dismiss. And they didn't attach the exhibits to the second amended complaint to the appendix to this court. Also, one other point on this is the motion for reconsideration was not appealed at all. So they somehow came up with that information. They had that, Judge Kirsch, and they attached it, but again, they didn't reference it. And then on the fourth element is they didn't tie the allegations of what was being disputed from the CRA to Ocwen and say if Ocwen would have conducted a reasonable investigation, what would have changed? On those three elements, there are no factual allegations in the complaint whatsoever. And a couple other points there. It was the third complaint that they had, and actually they had a fourth, but they corrected other issues. And one thing you'll see in the record is they never filed, even after the deadline, a motion for leave to amend with a proffer of how they would cure the FCRA deficiencies at all. So there was never a formal motion for leave that was even denied. It was really just in the conclusion of a motion or a brief. They say, please give us leave to amend. They filed a reconsideration, and the judge said there was no good cause at all, and it was a lack of diligence. And that argument wasn't made in the opposition to the motion to dismiss. We believe the district court, in denying the reconsideration, completely acted within its discretion. And again, there was no separate motion for leave with an attached complaint making those allegations. So
Mr. Lynch, I'd like to move to standing.
Okay.
In the last number of years, our court has had a number of decisions with regard to what constitutes a concrete and particularized injury. I'm specifically thinking about the analog to common law. I asked Mr. Wooten about it, the various intangible injuries. Specifically, the intrusion upon seclusion, the invasion of privacy. Here we've got the 12 phone calls, we've got the hangers given to the neighbors. What is your best argument as to why that would not constitute a concrete and particularized injury of an intangible harm?
I knew when I came here, given the panel, you know this area of the law, and I think you've all have written on it. On those common law torts, the Pasillo case, I believe, is right on point. They weren't alleged in the complaint. We're here at summary judgment, but in the Pasillo case, I believe Judge Brennan and Judge Kirsch, you both were on that case. You specifically stated, even at summary judgment, it had to be alleged in the complaint, and it wasn't alleged in the complaint. We believe that's the easiest way to dismiss this. The second reason is if there's door knockers, if there's some sort of, credit or something like that. The act occurred But under this precedent in the Seventh Circuit, it's not enough that the act occurred. It has to materialize into harm. And all that was done by the plaintiff in this case when we filed summary judgment is they filed a declaration with a bunch of self-serving allegations that weren't supported by any documents and weren't supported by any admissible testimony. So we believe we have it under both prongs, the waiver that it's not in the complaint. Second of all, there was nothing, any actual harm that materialized. So what did the door knocker do? You can't just say you had fear of the door knocker. That's not enough under the Seventh Circuit law. And what did the foreclosure do? You've got cases in the Seventh Circuit saying just having to hire an attorney isn't enough and just having to file a lawsuit's not enough. What's the actual materialized harm? And they didn't have it. One other point here, this was 5 years of litigation with a lot of discovery, and there were several motions in limine that were granted in our favor. Some were medical evidence, some were credit reporting documents, and none of those motions in limine were appealed. And we believe when you look at standing and you look at whether the actual materialized harm occurred, maybe hypothetically in another case some of these things could have been harm, but you have to look at the record in this case and was there any admissible evidence of actual materialized harm? And in this record, just like the district court stated, there is no admissible evidence.
Mr. Lynch, though, what about, my review of the record shows that on February 24th, 2018, Quicken Loans requested her credit report from TransUnion, and on May 12, 2018, Chase Card did the same thing. The record indicates that presumably the credit report was disseminated to both Quicken Loans and Chase, which contained her inaccurate credit reporting. Why is that not enough? Why under our cases and why under TransUnion is just simple reputational harm not enough to confer standing?
First of all, none of that is alleged in the complaint.
I know, but we're at the summary judgment stage, so that's different. And our cases, in our cases, at least in my review of our cases, when we talk about standing, we review the record at summary judgment. We're reviewing the record, not just the complaint.
And my understanding of the Seventh Circuit still has to be in the complaint. Then you look at those same allegations at summary judgment, but I understand. So my understanding, Judge Kirsch, is you still have to show reputational harm, and there's no evidence of reputational harm. It never materialized into reputational harm.
Well, I think she testified, or she had a deposition that a company called OneMain denied a loan request in February 2018. And that was at the same time that Oswin was reporting her existing loan as severely delinquent.
The OneMain documents were excluded by a motion in limine, and that's just self-serving testimony. No documents from OneMain ever came into evidence. There was no testimony from OneMain. That's just her self-serving testimony saying, just like there is some other testimony from her husband that her credit's all messed up and we couldn't even get a roof. So again,
Right.
It's the admissible evidence, Judge Kirsch, that is missing. I'm not saying that under different records and different cases that may give rise to Article 3 standing, but in this case, all we have is their own self-serving statements and a declaration. There's no admissible evidence other than her testimony.
Mr. Lynch, we've long held that a plaintiff's own, quote, self-serving, unquote, testimony is sufficient to create a material fact dispute as long as it isn't conjecture and it's based on the plaintiff's own first-hand knowledge. So why would it not be sufficient for Freeman, for instance, to point to her husband's testimony that the couple had difficulty getting a roof done on credit?
Well, first of all, I'll answer it a number of ways. Her husband's testimony about the roof had no causal connection to reporting from Ocwen at all. None at all. Her saying the credit's all messed up and they couldn't get a roof, she obviously had filed bankruptcy. She had other things on her credit report. No causal connection to Ocwen. Also, my understanding is the standard on Article 3 injury is the plaintiff has the burden of proof and has to present admissible evidence. It's not a genuine issue of material fact standard like on summary judgment that the Article 3 burden is higher and you actually have to prove it by admissible evidence, the injury in fact. It's not a just, if there was a material issue of genuine or material issue of genuine fact on Article 3 injury, we don't believe that's the standard. The standard is the plaintiff needs to prove it. There's so much causal connection. There's two things. You have to have a harm that's actually materialized, and you have to have the causal connection between the actual harm that materialized in Ocwen's reporting. That's what's missing here. They don't have a letter from a creditor saying, we're denying credit because Ocwen reported her. And we believe, again, I understand, Judge, about self-serving statements being enough to get past summary judgment, but we believe you just can't say under the Seventh Circuit precedent that I'm upset and I had, anguish. You've got to show some harm from that actually materialized, and you've got to tie it to the act.
Yeah.
I don't have any other questions.
I don't have any other questions either.
Thank you very much.
Thank you, Mr. Lynch.
Thank you so very much. Thank you. All right. We're going to give Mr. Wooten those 3 minutes.
Thank you, Your Honor.
Do you think, in retrospect, you could, a lot of stress might have been avoided if she had just gone back into bankruptcy court to fix any errors, or not?
Your Honor, to be clear, the litigation has been split in the district court. There is a pending discharge injunction claim in the district court, bankruptcy court, related to the bankruptcy violations that is separate and apart from these consumer claims. While there may be some overlap, there is no complete overlap. But the issue in our case here is that, as we know, the discharge injunction is somewhat limited and is primarily injunctive, and we don't really have the opportunity to enforce the rights that we have under the consumer statutes in bankruptcy court.
Well, are there any credit reports in the record
Yes, ma'am.
that demonstrate a drop in credit score from Ocwen reporting any erroneous information after that first bankruptcy was settled?
Your Honor, I'm not certain if there's a credit report in the record. It's universally understood that foreclosure and bankruptcy are the two biggest things that can impact your credit negatively under the universal credit scoring. I don't know if there's a credit report in the appendix or not. I can't answer that, Your Honor. Now, as to Mr. Lynch's allegations, essentially this is no harm, no foul in his mind. He does not acknowledge that litigation was necessary to prevent them from taking her home. He's made passing mention, dismissive mention of the idea that Ms. Freeman had to pay money for attorneys to make that happen, to not get steamrolled by Ocwen in a foreclosure case at a time when she was 3 months ahead in her payments by Ocwen's own admission. So she suffered concrete harm prior to filing suit in this case, and we've never held in this circuit that a creditor could sue on a debt that was not in default, that the debtor was not even behind on, and not violate the FDCPA. Now, concrete harm involves the money she had to spend to keep from getting steamrolled by Ocwen in foreclosure court, as well as the stress she experienced. And Ocwen has tried to make that go away by saying, well, we stopped after suit was filed. But that is nothing more than a mitigation of damage argument. That is not grounds to say there's not standing under Article 3 and there was an injury at the time suit was filed. One thing I need to emphasize, and I'm very quickly, I'm afraid there's confusion. We have never claim that we disputed to Aquin. We used the words in our pleading at 279, Aquin willfully and or negligently violated 1681 S2B by failing to conduct a reasonable investigation upon receiving notice of Freeman's dispute from one or more consumer reporting agencies and or by failing to review all relevant information provided by the consumer reporting agencies and or by failing to appropriately report the results of the investigations and or by failing to appropriately modify and or delete the inaccurate information. And by the way, in their brief, pages 6 through 8, they've admitted all their information was inaccurate. They discovered that investigating notices of error sent under RESPA.
Mr. Wooten?
Yes, sir.
You made reference to AA 239 in the appendix. It's
Yes,
a
sir.
non-party document production with a bait stamp TU. What is that document? It looks pretty technical, and who's it coming from?
Yes, sir.
How is the district court supposed to interpret that document? I looked at that document, right? I can't figure it out.
Right. So,
I mean,
Your Honor,
how would the
again,
district judge interpret that?
we didn't ask her to. We never got past motion to dismiss with that.
I know that's the
Right.
whole point.
But my point is what we said is that courts are familiar with the allegation that there are ACDVs, which that's what this is. It's an ACDV.
We're generalist judges.
Yes,
Mr.
sir.
Wooten.
Yes, sir. But
If Judge
well,
Easterbrook was here, he would remind you that. So we are generalists. Okay?
yes, I understand, Your Honor, and I understand that these statutes can be very highly specialized. Now, again, we brought up the fact that these were in the record as part of the motion for reconsideration. But at the pleading stage, it has always been enough to say one or more credit reporting agencies provided the dispute to the furnisher. They failed to reinvestigate, and we suffered harm. That's where we were. And I'm afraid some of the confusion is because we're partially talking about summary judgment evidence with the FDCPA, and we're talking about a motion to dismiss standard with the FCRA. And it's been a bit conflated, and that may be partially my fault because I said...
I'm not certain you're responding to the question, though.
I'm sorry, Your Honor.
A non-party TU bait stamp?
Yes, so that document is what the credit reporting world calls an ACDV. It is transmitted electronically by a credit reporting agency to a furnisher. And in this case, it has in the top left, or actually it's because it's sideways, so it'd be your lower left, but it has Damona Freeman's name and her information, and it says right above her name, subscriber, which is the furnisher, that is Aquin, response date, February 13th of 2018. To comply with FCRA, a response is required by 2/26/18. Date entered 2/2/18. Date received 2/2/18.
And who's this document coming from?
Coming from the CRA and going to Aquin.
So was that Equifax here?
So this document appears to come from TransUnion.
TransUnion, thank you.
But it says right above the date where it says subscriber response date, 2/13/18, right above that it says the originating bureau is EFX, which we all in the credit reporting world know as Equifax. So what this means is this is a TU record of an ACDV that Equifax sent to Aquin with a response date required by February 26th of 2018.
Thank you.
But how could we have ever known that?
Your Honor, if we were at summary judgment and you were this confused, I would have failed you as a lawyer. But at the pleading stage, we didn't have to be able to describe this in this detail. The reason we could is because this came out in the litigation between the motion to dismiss and the summary judgment on the FDCPA. What I'm saying is under the pleading standard of Rule 8, it has always been sufficient for us to say that there was a dispute because the dispute is a term of art under the FCRA that means that the furnisher, that the consumer disputed to a credit reporting agency, and the credit reporting agency sent one of these documents we're looking at, AA 239, to the furnisher, triggering their duty to respond.
Okay.
Thank you.
Anything else? Anything else?
Any
No.
questions I can answer for you, because I apologize for creating confusion.
No, I think that we're ready
Thank you
to tell you that we will take the case under advisement, and we thank both of you.
Thank you, Your Honor.
Thank you, Mr. Wooten. Thank you, Mr. Lynch.
Going to call the second case as soon as the courtroom is cleared a bit. Let's see. Okay. Case number 2. 23-1463, Nathaniel Pryor versus Michael Corrigan. Ms. Dickmar. Good morning.
Good morning, Your Honor. May it please the court, counsel. I'm Irene Dimkar, and I represent the plaintiff, Nathaniel Pryor. We're asking the court to reverse the order granting summary judgment to the defendants and to consider granting it to the plaintiff on the claims of false arrest, malicious prosecution, excessive force, the tackle, and the first 2 of 3 searches. We're also asking the court to vacate the jury verdict and remand for a new trial because of cumulative effect of errors at trial. Now, regarding summary judgment, the court based its decision, made a determination upon viewing 2 dash camera videos. It determined that there was probable cause for arrest and malicious prosecution, and that there should be qualified immunity for the tackle. I'd like to address the videos first. The court applied its own interpretation to the videos, usurping the role of the jury. In the Kalin case, this court has held that it should be a rare case where the video evidence leaves no room for interpretation by the finder of fact.
Well, Ms. Dimkar, Scott versus Harris, the Supreme Court decision from 2007, does allow the court to view the video.
Yes.
I'll concede that there are instances when you view a video and there can be multiple interpretations. There's also many instances when you review a video and there's not. Why does this fall into a multiple interpretation category and not a clear from the video category?
Well, first of all, Scott involved a high-speed chase, and the plaintiff was saying that there wasn't
This was sort of a low-speed chase.
very low.
No, he was getting away, right? I mean, I know you're saying that wasn't what he was doing, but from all accounts in that video, it's hard to conclude that that's not what he was doing.
Well, we contend that he was not fleeing a stop, and we think the jury should have looked at that video.
Usually,
Well, they did see the video, correct? The jury did.
They saw the video, but they weren't dealing with false arrest. They were only dealing with 2 punches and the 3rd search.
Correct.
That's all they were
which, by
dealing
the way,
with.
the defendant said did not occur.
Pardon me?
The defendant's defense was that the 3rd search did not occur.
That's correct.
And you're making claims that we should reverse based on your argument where the defendant said it never occurred and the jury found by the defendant. For the defendant, what basis is there to reverse that?
Well, you're talking about the 3rd search.
The 3rd
Okay.
You're saying the 3rd search wasn't reasonable. The defendant said the 3rd search never occurred. The defendant won. And now you're asking us to reverse and grant summary judgment for the plaintiff and conclude that the 3rd search wasn't reasonable when it didn't occur, which is a weird argument.
Well, the judge also instructed the jury that it was incident to an arrest, and that's why the search would have been okay.
No, but they found for the okay, go ahead. I understand.
So-
So you're saying you don't know what the jury concluded. They may have concluded that it was incident to a lawful arrest.
That's right, because they were instructed on that.
Okay.
They were instructed that there was an arrest. They weren't told anything about the arrest or what the arrest was for, but they were told that the search was incident to the arrest. So the trial was very strange, Judge Kirsch. You have to understand that because it only involved 2 punches and 1 of 3 searches. It was very difficult to determine what was going to come in and what wasn't going to come in. If I was on the jury, I would have been totally confused about what was going on, because it was not clear what they were supposed to decide. And all this information came in, I'll get to this in a minute, but of the drug surveillance and everything else, that this was an investigation, it was a dangerous situation. They were, of course, they were overwhelmed by, what they were hearing.
General verdict or special verdict?
Pardon me?
General verdict or special verdict?
General.
General verdict, thank you.
So we say that the plaintiff was not fleeing a traffic stop. He was moving towards the police. 2 police officers ran past him. They didn't consider him a flight risk. He was not moving fast. I mean, the trial judge described it as ambling, shuffling, lumbering, whatever. You could see he's not running. His pants are falling down. He was trying to get in front of the dash camera. And if he hadn't got in front of that dash camera, we wouldn't have those videos.
Well, and
Well,
we've seen.
there are two, oh, I'm sorry.
Go ahead, Judge Rover.
There are 2 ways to think about that, seems to me. Of course, Mr. Pryor claims he just wanted to get himself in front of the dash cam for his protection. But there are 2 ways to think about it. One would be, it seems to me, he was moving quickly, yes, to get himself in front of the dash cam for his protection. But the second way to think about it is he was thinking about fleeing, started down the driveway, but then decided it was, too futile or too dangerous and stopped and put his hands up in front of the police car. And for me, it certainly isn't clear which of the 2 it might have been.
Well, then it would be a question for the jury, if that's the case. I mean, we brought a motion for summary judgment thinking the videos were so clear that we should have summary judgment. And of course, the defendants, moved for summary judgment themselves. What the court below said is if he was trying to get away, it wasn't much of a getaway. He wasn't moving fast. He was going towards a police officer. And he gave his reasons why he left the car. He said it could have gotten bad quick. I know what happens. I know what happens to black men in vans. If I stayed in the van, they would have assumed I was reaching for something or concealing something. I want to make myself visible and show that I was not a threat. And so,
Excuse me. Go ahead. No, go ahead.
No, I finished the thought. So I want to hear your question.
I think we ought to go on, if you don't mind, to the evidentiary decisions at trial.
Sure. Regarding whether there was obstruction of a peace officer, we do have the defendant's Rule 36 admission that they were not claiming they had probable cause to arrest the plaintiff for any crime other than resisting arrest. And for resisting arrest, you have to have an underlying crime. And there's
Well,
no
not at the time. Not in
Right.
2015, you didn't.
Yes, you did. Yes, you did.
Where did the statute say that? I might have missed it.
Not the statute. It was the statute leaves room for interpretation. 2 court cases we cited said that you need an underlying crime. You need an underlying crime. It got codified. Yes, it got codified after this case, but still, it was understood that there had to be an underlying crime. And we believe the defendants conceded themselves into summary judgment for the plaintiff. Rule 36 is supposed to eliminate issues from a case. Advisory committee says it's comparable to stipulation. When you say, I'm not claiming I have probable cause for anything except resisting arrest.
But
then you're stuck with that.
that's not quite right, because we have cases that say, let me give you an example. An officer says, officer's in a high crime area, okay, let's say, and an officer makes an arrest, and you ask the officer in a deposition, were you scared? Nope, I wasn't scared. I weigh 240 pounds, I have black belt in karate, I wasn't scared. That's not the test. It's not the test whether Officer Smith was scared. It's the test whether a reasonable officer in Officer Smith's position would have been scared because it was a high crime area. Why is that not the same here? If this officer says, I arrested for resisting, okay, but there are other charges that could apply, why does it make any difference as to what this particular officer said in a response to a request for an admission?
He didn't say, I was arresting for resisting arrest. He said, I do not claim I had probable cause for any crime other than resisting
But
arrest.
what difference does that make if there is, in fact, probable cause for another crime?
Because it's supposed to be conclusive. Rule 36 is supposed to take issues out of the case. The rule explicitly permits admission of matters relating to facts, application of law to facts, and opinions about either. This was application of law to fact. They said, we're not going there. We're not saying we had probable cause for anything except resisting arrest. You cannot go up to somebody and arrest the person for resisting arrest. There has to be an arrest. And the case law says that, and now the statute says that too. When he left the van, there is case law, the Kotlinski case, an Illinois case, says it is not a crime to leave the van. You can get out of the van. That itself is not a crime. Moving 20 feet, when he's not moving fast, he's not, I disagree with Judge Rovner. I don't think he's thinking about whether I can run or not. This man could not run. He's a large man, and his pants are falling down. He goes about 20 feet and he passes two officers past him, and they said, one of them, Christoffel said, he acted confused. He was confused. He was like, okay, here I am. And the defendant said.
But why, let me ask you one question. Let's say there was not probable cause for resisting or obstructing a police officer. Why in this case wouldn't there at least be, I forgot what the phrase is. It just slipped my mind. It's sort of close to probable cause, or I forgot what the phrase
Arguable.
is. Arguable. That's it, thank you. Arguable probable cause here for resisting. You have a van. Police officers pull over a van, okay? One guy jumps out and darts one way. Another guy jumps out and kind of moves the other way. And the police officers chase the guy that they're looking for into the backyard, and then they tackle and arrest the guy that's moving the other way from the van. Why isn't there at least arguable probable cause here?
First of all, I wanted to correct Your Honor. They don't know who's in the van. They don't know that Raymond Johnson's in the van. They just know that one man took off into the backyard. That's all they know.
Well, they were investigating a drug activity. I mean, they had a tip that they were dealing drugs, and then they pulled the van over, and he darts out of the van. That's
right. A
bad.
man started out of the van. I just wanted to say that they don't know who's in the van. And we could talk about the surveillance itself. The surveillance amounted to nothing. All they had was a tip. All they had was a tip that there was cocaine being cooked at 1020 Kane Street. Why didn't they get a warrant for the address? That's their focus.
They probably didn't have probable cause.
They didn't. They
Doesn't
didn't.
matter. What difference does it make?
They didn't have probable cause to
search.
to search, and didn't have probable cause to stop the van for drug activity, which is what the judge told the jury was involved. I mean, the trial was, this is a traffic stop related to drug activity.
Whoa. I don't know what just happened there. Sorry.
And there is no proof that there was drug activity. There was nothing they saw that was confirming anything when they sat across. They sat in a church parking lot that was up the street in Kitty Corner. All they saw was a van, and they didn't have a license plate. They didn't have a make, a model, a color, anything. They saw the van go down the street, and they said, "Let's follow that van." So there's a lot of missing, knowledge here. They know that they've been told there's a Raymond Johnson who's in the house cooking cocaine, and he's going to be in a van. They see a van. They don't see anybody get in. They don't see anybody get out. See no criminal activity. Van pulls out, and they say, "Let's follow the van." Well, that's fine. They can follow anything they want, and they can, the arrest is for a traffic stop. It's a pretext stop, but that's legal, right? So they can do that. But then to elevate it and bootstrap themselves into saying that this was a drug raid fraught with danger, which is how the defendants described it. This is not a drug raid. This is a traffic stop, and what you have is a man who's passively standing. He's compliant. He is standing right there when he gets tripped to the ground. The qualified immunity in this case was only for the tackle, by the way. You
Right.
mentioned this
Right.
The probable cause or you know, that there wasn't any kind of ruling that this was, that there was qualified immunity on the probable.
Right.
The judge's rule is
For
no
the
probable
punches,
cause.
right.
And I would ask the court that not to insert that into the case at this time, that the qualified immunity was for the excessive force.
Ms. Dykna, I would really like to ask you something, and time is truly running out.
Sure.
And here's what I want to ask you on this subject. The court instructed the jurors that Pryor was not arrested or charged with any drug-related offense, right?
Yes.
Why wasn't that enough to counter the prejudice from the officers' evidence that they were conducting drug surveillance?
We believe that that was like a wink and a nod. It was like he wasn't arrested for a drug charge, and he wasn't charged with it. It either meant that he got away with something, because we had that whole search into the pants where the officer is saying, it's falling, it's dropping, it's falling, it's dropping. And Nathaniel Pryor wasn't able to say, you know, I never had drugs on me. And whenever it really, the inference to the jury was that there were drugs in his pants. And then he was not charged. Well, what was he charged with? Well, maybe he's a fugitive from justice. Maybe he committed some heinous crime. You know, the jury could have thought anything. We asked that the jury be told that he was charged with resisting arrest, that there was an arrest, but it was for resisting arrest, and that it was not any of their concern. So being told that he was not charged with or arrested with a drug offense created more problems, and we said that to court. We think this creates more problems because the jury's going to say, well, what was he arrested for? Gee, it must have been something terrible. So that was not. We thought
Okay.
that was an error.
Unless either Judge Brennan or Judge Kirsch has any questions, I'm going to ask you to please stop there.
May I have rebuttal time?
Yeah, I will give you some, yes,
Thank you. Thank you very
Okay.
much. Thank you.
because I will. Okay, all right.
Okay, thank you.
So, Gabe. Oh,
May it please the court,
hi, Ms. Proctor.
on behalf,
Okay.
good morning. On behalf of the appellees, I will address the trial court's evidentiary rulings at trial. My colleague, Mr. O'Donnell, will address the trial court's summary judgment rulings at issue in this appeal. To be clear, I think if the court, if you have not, you will review the court's trial transcript. Judge Seeger worked very, very hard to ensure a fair trial. And the framework and the standard of review of the trial court's evidentiary rulings are an abuse of discretion. And we have not heard anything, and I don't believe the plaintiff has presented any evidence that there's any grounds to vacate the jury verdict.
Can I ask you one question?
Sure.
The answer may be harmless, okay? So the answer may be harmless, but that's not the answer I want you to give me. When the judge admitted the video of Corrigan's statements, okay, and said that they fell under a hearsay exception, I think Judge Seeger concluded that they fell under the then existing state of mind exception. How so? And the reason I ask that is it concerns me. We live in a world now where police officers, and in some cases, individuals that are suspected of crimes, have adapted to cameras. When I was U.S. Attorney, there was a big fight over whether you have dashboard cameras and body cameras. The world has adapted because we have these things. And would it be appropriate for us, in an opinion, to say that a police officer sort of after the fact, after the arrest, just after the fight, right, statements and that are caught on a dash cam video should be admitted to show the officer's then existing state of mind? State of mind is more like excited utterance type stuff than if an officer comes in front of a video camera and justifies his prior actions. Now here, of course, he testified, so it may be he testified to what he saw in the video and what happened in the video. It's just cumulative what happened. But why should that language as exchange have been admitted?
Well, in the trial, the plaintiff wanted, the video admitted into evidence, and the plaintiff wanted it admitted and the jury to hear everything up to the point where Officer Corrigan responded to the plaintiff's questions.
I actually think that's a reasonable position.
Well, but you have to listen to what the plaintiff is saying in the video. He asked Officer Corrigan no less than 15 times while he was on the ground, after he was secured. Sir, what seems to be the problem? Sir, what seems to be the problem? To cut it off there really would give an inaccurate picture of what happened. It wasn't offered for the truth of the matter asserted, and it was a conversation between Officer Corrigan
If it wasn't
and the
offered
plaintiff.
if it wasn't offered for the truth, then why was it offered?
It was offered to show Officer Corrigan's state of mind, and this is within seconds after this whole event took place, okay, after the takedown and after securing the plaintiff. It did go to the reasonableness of the use of force, and I think we have to keep in mind at trial the only claim against Officer Corrigan was whether or not he used excessive force in violation of the Fourth Amendment, and Officer Corrigan's state of mind goes to the reasonableness of the force. He simply answered Mr. Pryor's question, which was, "What's the problem?" And he said, and it was a conversation. It was, "Sir, Officer Corrigan's response was, well, when just want to get it exactly, that when police stop a vehicle, people don't run." That was the extent of it, and it also goes to punitive damages. The plaintiff was seeking punitive damages, which in order to prevail, they have to demonstrate actual malice. In order for Officer Corrigan to defend that claim, the judge also thought it was probative of whether or not, on the issue of punitive damages, the lack of malice. Officer Corrigan simply explained why he did what he did. And it really was not a statement of the law, and if this court disagrees, the judge's jury instruction was very clear on that. It's at docket 304, page 22 of 38. The jury instruction clearly stated that any statement of law comes from the court, not the parties, including the conversation between the plaintiff and Corrigan in the video. So, to the extent...
the malice argument may be a good one. I'm not sure the state of mind. I think state of mind is for the truth of the matter asserted. If that's the hearsay exception. If it's not offered for the truth of the matter asserted, it's just offered to show that it was said. And here, that would be irrelevant, that anything was said. I am with you on you can't put in the question and not the answer, right? The plaintiff can't ask the question and then cut the video off at the answer.
And that was that was in part the judge's thinking.
But my question is a broader question
Sure.
with respect to this case, which is what evidence here, what exchanges between police and defendants should be coming in pursuant to body cameras or dash cameras? We're going to have this a lot, where defendants make statements or police officers make statements, and we got a trial, and the police officer can testify to what he or she said, and presumably so can, in this case, the plaintiff.
Well, I think each case has to be, analyzed on its own facts. In today's world, police officers wear body cams. In this case, the audio was and the contemporaneous conversation was captured on the
I think
dash
that's
cam.
the issue. I think we just have to be careful not to go too broad to suggest that these are always admissible as, non-hearsay or as a hearsay exception.
We do not disagree. I think each case needs to be decided on its own facts, and we think that the trial court got it right here.
Now, Ms. Proctor, I think you're the right person to ask this of. I can see why the district court judge allowed in the evidence that the police were conducting surveillance of what they thought was a drug trial. But I am troubled by the fact that he did not then allow in evidence that no drugs were found on any of the suspects. The fact of drug crime surveillance, although very relevant, of course, is still very prejudicial. And there was such an easy way to counter that prejudice, just by saying no drugs were found. When a judge is faced with highly prejudicial but probative evidence, and there's an easy way to keep the probative value but get rid of the prejudice, how is it not error to fail to do that?
Well, we do not believe the trial court committed error. I mean, he did allow evidence that this was a drug investigation. He was very clear that the defense, which we did not do, was not to suggest that Mr. Pryor was involved in the drug trade or that he himself was dealing drugs.
No, but look, I mean, the court seemed to think it was fixing the problem by saying that the defendants could not suggest Pryor was involved in the drug trade, and Pryor could not say that he was not involved in the drug trade. But is that an even trade? I mean, the officers get in the evidence that they thought Pryor might be involved in the drug trade. Then why shouldn't Pryor be able to say that no drugs were found anywhere?
Well, we're dealing with an abuse of discretion standard, and we don't believe that the plaintiff has demonstrated that Judge Seeger committed an abuse of discretion because there was a limiting instruction. If you believe that there was some prejudice, there was a limiting instruction. At the beginning of the trial, the judge instructed the jury that plaintiff was not arrested for a drug-related offense and that plaintiff was not charged with a drug-related offense. He even barred evidence that there was $690 of cash found on Mr. Pryor's person, and the written jury instruction, docket 304, at page 22 out of 38, clearly instructed the jury that during the trial you heard evidence that police performed the traffic stop in connection with a drug investigation. However, the judge instructed the jury that the plaintiff was not arrested for a drug-related offense and not charged with a drug-related offense. I think it accomplished the same thing and is not an abuse of discretion. I think he worked very hard to ensure a fair trial. Maybe some judges would disagree and they would maybe do it differently in the way that you suggested, but we believe the limiting instruction here cures any alleged abuse of, cures any prejudice and is not an abuse of discretion.
And let me ask you one other question. If the new Illinois law, codified in 720 ILCS 5/31-1 in paren had been in effect at the time, how do you think that would have affected the outcome of this case?
Your Honor, that really speaks to the summary judgment rulings,
Okay,
and my
fine.
colleague, Mr. O'Donnell, is prepared to address that point.
Great, okay.
Thank
All
you.
right, then you may take a rest.
Good morning, judges.
And good morning, Mr. O'Donnell, and maybe you'll start out with an answer.
I will address that specific question. And as Judge Kurtz correctly noted, that at the time in which this incident happened, 2015, Section D was not part of the law. And so this
Right.
underlying crime wasn't an issue. But even if it was, Corrigan would have had probable cause to resist him based off of obstruction. Because as the video clearly shows, plaintiff got out of a vehicle, so this was a lawful traffic stop. There's no debating that this was a lawful traffic stop. Plaintiff opened up the door, he closed the door, and then he proceeded south away from the traffic stop. Once he proceeded south away from the traffic stop, that is obstruction. That would have been the underlying charge, of which he could have then arrested him for.
What if
So-
he was walking down the snow-covered driveway at a medium pace, turns around, holds up his hands? At what point is that an obstruction?
So the obstruction is just the fact of him leaving a lawful traffic stop away from the actual traffic stop. So the fact that he's moving away I mean, whether or not he's walking, maybe he's jogging, even with his hands up. In this situation, this is a little bit different because if you saw the video, his hands are up, but then you could see his hands go down. And once his hands go down, that's when Officer Corrigan approached him, felt him resisting and sort of pushing him into his body, because again, it's really important to understand Mr. Pryor was over 75 pounds heavier than Corrigan. And so that act of resistance is what prompted the takedown.
Part of the challenge here is we're not talking about a minute or 2 minutes. We're talking about 12 seconds or so. So each second bears a certain weight, and then both sides obviously try to attach a conclusion to that. In only 12 seconds, then we're supposed to conclude the obstruction and or the conclusion of an arrest. Is that your position?
The position is that when Officer Corrigan got out of the vehicle to the time of which he approached him was actually only about 4 to 5 seconds. I mean, so the fact that he got out of his vehicle and moved south, and then to the time of which was a takedown, that was the total 12 seconds. But the obstruction is simply him moving away from a lawful traffic stop. In any situation in which an officer, and again, this is based off of an objective standard, which I would get to in terms of the judicial admission, a reasonable officer in Officer Corrigan's shoes would have believed that this individual was fleeing a traffic stop. That action alone constitutes obstruction.
Let me ask you a summary judgment related question. Obviously, the district court here was placed in a challenging position with regard to initially the motion to dismiss, which removed some of the claims, then the summary judgment, and then the bifurcation between the tackle and then the hitting.
Correct.
Put to the side the argument of whether there should have been a bifurcation. When one views the video, one can wince at the takedown, the leg takedown, especially in the world of excessive force. But that was a matter of summary judgment, but the hitting was not.
Correct.
How defend that position?
Sure, and I think the trial court correctly ruled that the initial takedown was based off of qualified immunity. So he went right into the second part of the analysis of the qualified immunity. He didn't even get into whether or not there was a violation of the protected right. Instead, he asked plaintiff, it is now your burden to prove an analogous case to show a situation in which an individual flees a traffic stop and cannot be tackled. And we showed one case in particular that I think is very important in this case is Hollingsworth versus the city of Aurora. That was an opinion that came down in 2014, which was only 1 year prior to this incident. And it's also important because it's the city of Aurora. Corrigan works for the city of Aurora. It was his colleague that was part of this case. And in that case, it was a very similar situation in which an individual fled a traffic stop or attempted to flee a traffic stop that had nothing to do with the underlying allegations of a robbery. The person left within 3 seconds. The officer tackled that individual, and the court found that that tackle was reasonable under the circumstances. And to this day, plaintiff has not brought forth one case in which an individual who flees a traffic stop cannot be tackled. And that's the primary ruling for the summary judgment, was that qualified immunity. And so then he said the qualified immunity, you are good for the takedown, but the subsequent tackles or the subsequent punches were a genuine issue of material fact, because plaintiff is alleging that he wasn't resisting. Corrigan was alleging that he was resisting, and that's why he punched him. Plaintiff alleged that he was punched in the face 2 times. Corrigan is alleging, I hit you in the arm. And so those two situations are different because there was a genuine issue of material fact as related to the punches, but not as it relates to the takedown.
You wanted to touch on the Rule 36?
I did. And I think this is plaintiff's overarching argument, is that a judicial admission here precludes Officer Corrigan and all of the other 11 defendants from arguing that there was probable cause for obstruction. Because as the court ruled, Officer Corrigan had probable cause based off of obstruction. Now, it's important to note that Officer Corrigan's subjective belief as to why he believed that he had probable cause to arrest is irrelevant to the probable cause analysis. And the reason why it's irrelevant is because the probable cause analysis is an objective one. It's based off of what a reasonable officer would have done if he was in Officer Corrigan's viewpoint. And implicit in that analysis is it's the court's job to determine whether or not there's probable cause based off of the arrest when the facts are not in dispute. The facts are not in dispute here because the video clearly shows what plaintiff did. The only disputes that plaintiffs say in regards to the video is he's alleging that he's walking. Well, judges, you can look at the video. He's not walking, and you can make the own determination. And then I just want to put one other point. Plaintiff is alleging that he went to the south of the driveway because he wanted to de-escalate the situation, and he wanted to get in front of the cop car so that they can get this on video. But it's important to note that plaintiff's subjective intentions is irrelevant to a probable cause analysis because it's not based off of what plaintiff believes. The probable cause analysis is based off what an objective, reasonable officer would have determined had he been in Officer Corrigan's shoes. And that's why the video definitively disproves plaintiff's argument about walking versus not walking. But again, this judicial admission, even if it was an admission, it can't stop the court from conducting its own probable cause analysis, which is exactly what the trial court did here. Regardless of the admission, the courts, and this is done multiple times in the Seventh Circuit, you can determine probable cause based off of any offense at the time, regardless of Officer Corrigan's subjective belief. And that's why we believe that this judicial admission is irrelevant to the probable cause analysis. And then, if I may, just a quick point in terms of the video. This video isn't poor in quality. It doesn't lack all audio. It isn't blurry. I mean, judges, you could see exactly what happened in this video, and you can see exactly what Officer Corrigan saw in this video. And that's why you're able to make that determination of probable cause. Or if there was not probable cause, there at least would be arguable probable cause, because as Judge Kirk referenced, we did raise that as affirmative defense. We did raise qualified immunity.
Thank you.
Thank you, judges.
Thank you very much. Ms. Dykman. All right, let's give Ms. Dykma 3 minutes, please.
Thank you. First of all, you do have to have an underlying crime for resisting arrest. I got the page in my brief, page 18, cited the Abbott case, the Slaymaker case, and the Torres case. That was the case law prior to this case occurring. The state legislature then codified it and then added that extra subdivision, the subsection that says that you have to have an underlying crime. So if a Rule 36 admission is going to mean anything, it's got to mean that you're taking something out of the case. That's the whole point of having admissions. If you say, I am not claiming that I had probable cause for any crime other than resisting arrest, that means you have walked into summary judgment for the plaintiff. You said, I don't have any underlying offense. And the court, and they also admitted, there was another admission of theirs, that there was no underlying offense. And the judge said there's no underlying offense. So there is no underlying offense. You can't just have a resisting arrest. That would create havoc. A police officer could just come up to somebody and just say, I'm arresting you for resisting arrest. Oh, you're not resisting? Well, I can arrest you anyways.
Ms. Dimkar, I want to take you to what I think is maybe one of your stronger arguments. Okay. This distinction that Judge Seeger made between the excessive force in the tackle and the punching, that one goes to the jury and one does not. We've all seen the video. Mr. O'Donnell's response is the judge accelerated to the QI call on the tackle, but allowed the hitting to go. What are your thoughts?
Well, as far as the 2 punches are concerned, I did want to respond to what was said earlier. The officer is playing to the camera. When he's hitting,
I think it's fair to say both people might be playing to the camera, but go ahead.
When he is hitting him, the second hit, the trial judge mentions that the second hit is when he doesn't see any motion at all on Nathaniel Pryor. So this was a gratuitous hit, the second hit. I don't think this made a very difficult trial because you don't just have a tackle and 2 punches. You have things in between. What about straddling him? You got a big man sitting on top of a big man. He can't breathe. His face is in the snow and in the slush. Is that part of the tackle, or is that part of the 2 punches? And can he say that I was already reeling from the tackle because he hit his head on the concrete? And if his head had split open, might be here on a wrongful death case. Because this is serious stuff when the police do this. Was there proportionality to what the police officer did when he brought him down? And we're saying no. There was no proportionality. He had somebody he had him. The man was, call it surrendering, call it whatever you want to call it. He had his hands up. And for him to say, well, I took him down to the ground because he's bigger than me, I don't think police officers get to say that. To say, you're taller, you're bigger, you're whatever, so I get to do that. But splitting up the case was terrible, and that's why we had to have all these pretrial conferences and during trial trying to figure out what comes in and what doesn't come in. Because could Nathaniel Pryor say, the tackle was terrible. I felt terrible. My head was splitting. He couldn't even say where his injuries came from because it came from hitting the ground with his head and then being punched. So when he had bruises and lacerations in his face, where did it come from? And I think it's important that that this court take note of the fact that this was not, there was no reason for this bringing him down to the ground, and not in this way. He was not, at the point he was placed under arrest, he was not doing anything. He was standing there with his hands up, and he was passive.
Were his hands, do you believe his hands had started to move downward?
I think as the officer was coming towards him, he was reacting to it. He wasn't grabbing for anything. You don't see him grabbing for anything. He didn't have anything to grab for. He didn't have a gun on him. He didn't have anything. Maybe he grabbed to pull up his pants, maybe, but it dropped a little bit. But that's as Corrigan was approaching him. And Corrigan, it's very important to note that Corrigan says, get on the ground, when he is already standing there, standing still with his hands in the air. And Corrigan says, get on the ground, and about 2 seconds later, because it took 4 seconds for Corrigan to get from his car to where Nathaniel Pryor was, and about 2 seconds into it, he says, get on the ground, and then he slams him to the ground.
Well, where do you think it would be easier to restrain someone, standing up like that or on the ground?
Well, I don't think you slam somebody to the ground, especially when you know that all you have on this person is that he's a passenger in a traffic stop. That's all you have. This drug surveillance, I think we have to look at the facts of that drug surveillance. It didn't amount to anything. It didn't show any criminal activity. So for them to bolster themselves into this was a drug-related investigation, and for the judge to tell the jury the police performed a traffic stop in connection with a drug-related investigation. I mean, that was just so heavy. It was just so heavy-handed, for the jury to hear that. Then they have to think, well, the police officers must have known something. There must have been some drugs. They saw something. They knew something. They're just not telling us. So I think that was a problem, and I've used up my time.
I should say. All right, it's okay. All right. Thank you to everyone. Thank you to Ms. Dykmar and to Ms. Proctor and to Mr. O'Donnell. And the case will be taken under advisement, and the court is going to take a 10-minute recess. Okay, thank you very much, everyone. We're going to go on to case number 3, which is 23-1761, Monica Rangere versus the City of Rockford, Illinois. Mr. Urani, is that correct?
Yes, that's correct, Judge.
Thank you very much.
Thank you. And good morning again.
Morning.
May it please the court. My name is Joe Urani, and I, along with my partner John Kramer, are here today on behalf of the appellant, Monica Rangere. We respectfully request to reserve 5 minutes for rebuttal, which Mr. Kramer will do. We are respectfully asking this court to reverse the decision of the Federal District Court granting summary judgment on behalf of the City of Rockford. The main issues of this appeal I would like to address in my time before you are all the genuine issues of material fact that exist that render the granting of summary judgment inappropriate on plaintiff's retaliation claim, on her Title VII sex discrimination claim, her EPA violation claim, and her hostile work environment claim.
Mr. Urani, may I ask you, please, how many women and how many men had the role of senior manager at the city?
You know, Your Honor, I don't have the exact number of the differentiation. I believe that Ms. Rangere was one of the only women. There was, the majority of them were men. Ms. Rangere, I believe there were 2 others, if I'm not mistaken, but I don't know for sure.
And why is there no data in your information about what senior manager men and women earned at the city?
Well, I believe that information is there, Judge, and I think that that goes to the EPA claim. And I think, you know, the crux of the facts in this case are with respect to what Ms. Rangere experienced and what she went through every day. She knew she was working 2 different senior management jobs at all times from the beginning. And she knew that she was earning less by approximation because of all the extra work she was doing compared to what the male comparators were doing. I know there was a lot of discussion in the briefs and in the lower court's decision with respect to the exact dollar amount. I don't think there's any case law that requires an EPA plaintiff to know the exact dollar amount of what the comparators are making. She knew she was definitely earning less. And I think it also is part and parcel with respect to the claims of sex discrimination. It goes hand in hand because she was a woman. She was complaining about all the extra work she was doing from the beginning. Her original boss that hired her, Carrie Partridge, acknowledged in the only one review that she had that he acknowledged that he appreciated that she had the dual roles, the diversity procurement officer and the contract compliance officer roles, even though she was only hired for the first one. He acknowledged that and he appreciated that, and he also pressed forward in that review that he foresaw her roles expanding further and that her job description was going to be redefined. So from the beginning, she had the anticipation that she knew there was going to be a bigger role than she was just initially hired for on paper, at least. So I think that it goes heart and heart with the fact that she complained about the fact that she was had to work all these hours. She continuously complained about all of that, and then nothing was ever done about that with respect to when the new management came on board.
Now, just tell me this: is it your contention that anyone who worked for the city of Rockford and was a senior manager was a proper comparator to Ms. Rangere?
Well, yes and no. I mean, I think for purposes of this litigation, she testified to what she observed. I think she worked most closely with Carl Franzen and Mike Hackinson. And I don't think the law doesn't require that you have to have more than one comparator. And I think that based on her observations and her testimony in this case, it really just concentrates on those 2 gentlemen. There's really, I don't think that
What made them comparable to her in your view?
In my view, they were all senior managers. I think that's might be a point of dispute, which I think goes to the question of fact. They were all senior managers. They all had Mike Hackinson and Ms. Rangier reported to Nick Myers directly. They all had to go to the same meetings. There's internal documents that were produced by the defense that show that there was a senior management meeting on one of the schedules. And there's testimony, I think, that we go through in the briefs that show that the mayor at least acknowledged at one point the role of senior manager. And these group of people all had oversight over their specific areas. They all had to go to the same meetings and report on the oversight of that. Yes, they were different because by definition, they were different because they each controlled a different area. But they all worked in the same office. They all controlled their own specific area. Ms. Rangieri had 2 areas as opposed to Mr. Franzen and Mr. Hackinson. But the comparable part about that is that they were all on that same level of management.
Let me tell you the problem that I have been struggling with, and that is where is the evidence that any of the alleged maltreatment that she experienced had to do with gender? In other words, you say she was treated this way because of her gender, but why should we conclude that it was because of her gender?
Well, I think it goes back to the way she complained about that. She complained to the mayor in June of 2017, and she complained that she has all these other responsibilities, and she's not being paid for that. And she did in that complaint bring up the fact that it was her gender. And then even going a step before that, I mean, she complained about all the additional work that she had to do. And I guess, quote, for lack of a better word, it was more of like domestic things that she was required to do. She was required to always have food available at meetings. She was required to bring donuts. She was required to always be the one that decorated and did the grocery shopping for these events and clean up afterwards. The men didn't have to do that. She complained about that also to her boss, Nick Myers, on June 5th, of 2018. And then 2 days later, as she was leaving to go to a wedding, which she already had approved vacation time for, she was called into Nick Myers' office and terminated for alleged performance reviews that didn't come until the letter was given to her. But there was no specifics about those performance issues. That didn't come until the depositions in this case, where it was specified that the problems were these meetings that she allegedly ran 9 months before her termination, where Mr. Meyer and the mayor were upset with the way she conducted those meetings. So I think it all kind of, there's a very fact-intensive case. It all blends together, but the fact that she complained about that and she made it known that, hey, this is happening to me because I'm a woman. The men don't have to go out and decorate. The men don't have to do this. And by the way, from the beginning, I had these dual responsibilities, and they just kind of went ignored. You never really acknowledged that. I'm still doing the work, and you've never sat me down and let me know that, hey, this is what we're going to do. We're going to increase your wages. We're going to redefine your duties that Mr. Partridge indicated that was going to happen. And all of that escalated until, in our view, on June 5th, it all came to a head, and she complained to her direct boss. And then that was it. It was enough that they just didn't want to deal with it anymore, so they terminated her 2 days later. The nexus in time alone, I think, is a question of fact that renders this case, just on that issue alone, improper for summary judgment. A jury should decide whether or not that was proper. And I think part of the problem is that there's so many facts involved in this case, and the reason that it's so difficult really to argue it in an appeal situation is because all we are is arguing facts. There's so much here that should have been answered that wasn't answered in either the appellate review, in the lower court's opinion, or even in writing these briefs. It is just replete with facts that we don't know the answer to. And I think we request that you reverse that and let the jury decide these issues.
Thank you.
Thanks.
Morning, may it please the court. Josh Vincent on behalf of the defendant, City of Rockford. I probably couldn't disagree more with Mr. Urani's statement that the facts are complicated. This is a pretty simple and straightforward case. The Equal Pay Act is very clear that if you're going to make a claim that you're not getting the same pay as a male comparator in this case, you've got to show that the jobs involve the same skill, effort, and responsibilities. And the facts on that are extremely well settled in this case and completely uncontroverted. You couldn't have 3 jobs that couldn't be more different. And the plaintiff was charged with the responsibility of drawing more minority work to the city, more minority work contractors, women-owned businesses, so that they could do more business with the city. And she was also charged with making sure that those contractors, that their wage submissions complied with the Davis-Bacon Act and Illinois state prevailing wage laws. Her 2 comparators, one, Mr. Hankinson, he's the land transactions officer. That gentleman is basically the city's real estate broker or real estate agent. He goes out and he buys property for the city, he sells property for the city, he does title work, he does real estate closings, has absolutely no comparison whatsoever to the job that the plaintiff had. And the same is true with Carl Franzen. Mr. Franzen was the economic and community development coordinator. He's involved with enterprise zones, tax increment financing, bringing industry into the city, making sure subdivisions are built for people to live in, bringing business there for jobs. These are totally, completely different jobs with completely different responsibilities. And if you look at docket 77-5, page 30, where the plaintiff was asked point blank, do you contend that your responsibility, that your job involved the same skill, effort, and responsibility as these 2 other gentlemen? She says no, flat out. I mean, it's a flat out admission. There absolutely can't be an Equal Pay Act claim under the circumstances of this case, putting aside the fact that she's paid the identical amount as Mr. Hankinson. So there was no disparity in pay, even though, their jobs are different. There's no disparity in pay. And with regard to Mr. Franzen, the jobs are just simply not comparable. The sex discrimination case, failed in the district court for a very simple reason, not complicated at all. The reason was she couldn't identify a single male comparator, another male, who was fired who performed poorly on the job and was not fired. It's a classic sex discrimination case. Anytime you're going to make a claim like that, you're going to have to identify someone who, did the same thing wrong that you supposedly did wrong, but was treated better. She can't identify anybody on that. And that the argument on this point is completely forfeited because she never addresses any of that in her brief. Doesn't even respond to the district court's basis for entering summary judgment on that particular claim.
Can you address the suspicious timing? In other words, she complained of unequal treatment 2 days before she was terminated.
Well, the single biggest problem with that argument, Judge Rovner, is the plaintiff admitted that she never knew how much these men made. So it was literally impossible for her to have told her boss on the day that she claims that she's underpaid compared to these other men that work in the office when she admits on the record, and that's docket 77-4, page 55 of the PDF, page 211 of the miniscript. She admits right then and there she never knew what anybody else made. So you can't complain about being underpaid relative to a male or another person if you have no idea what they make. And that's what she admitted. So again, these are not complicated facts. The thrust of the argument here and the thrust of the brief, the entire theme of the brief, is someone who is contending, I worked harder than everybody else and I should have been paid more. That's not a discrimination case. That's just not a discrimination case. It never has been. It's about the closest you would ever find, I think, in the jurisprudence of this court on that sort of issue would be workload discrimination. She doesn't even try to articulate a workload discrimination case, and this court has previously held that workload discrimination is not an adverse employment action. Okay, giving someone a heavier workload is not an adverse employment action. But here you put that aside. You know, you got to keep in mind these are all FLSA exempt salaried employees. All right, so they're not punching a clock. Everybody's just expected to be there at a reasonable and predictable time in the office. And her contention is she's just working harder than everybody else. And you can't make a discrimination case out of something like that because there's no way to quantify it. It's a purely subjective assessment when someone says, I work harder than the next person. You know, and especially when their jobs aren't even the same. I mean, certainly, I'm sure there's plenty of lawyers in my office who will say they work a lot harder than I do, okay? But, that may be, or maybe I work harder than they do because I'm not as smart, okay? I can't write a brief in 2 or 3 days. Some people can. Some people, for me, it's going to take weeks to write a brief. But
Do you think you really want all this on the record?
At my age, Judge Rovner, I don't worry too much about that anymore.
At least there's no transcript, right? It's just recorded.
That's true. It's a good thing you guys don't allow transcripts of these hearings.
Is there any evidence in the record that prior to June 2018, anyone ever advised her that she was not meeting expectations?
Indirectly, yes. Okay, I mean, I certainly will concede that there isn't, a performance evaluation, which you might classically consider a write-up that says, you're in trouble. But I will say this, if you look at dockets 77-13 to 77-23, it's a series of exhibits, and you'll see that there's email exchanges where her boss, Nick Meyer, is making it very clear to her that she's not performing properly. She's bringing these problems to him, saying she has grave concerns about things without saying what her grave concerns are about, without identifying them. She comes to him with problems and she offers no solutions. And he points this out to her explicitly in emails.
It seems like everyone in this dynamic was very conflict averse. Nobody wanted to just have the difficult discussion with regard to either performance or the claim that the plaintiff was making.
That could be. I mean, she was aware there was a problem. All right. The evidence is also, again, not complicated, very clear. She, as the person in charge of minority and women business enterprises trying to bring those in the city, she was responsible for reaching out to that community, hosting meetings. The very first meeting that she hosted, she stood up, introduced herself, sat down, didn't run the meeting. The mayor had to step up and run the meeting himself. He was extremely upset about that. He complained to her boss, Nick Meyer, the legal director, about that. Nick spoke to her about it. That's uncontroverted. It's uncontroverted that she confided in Carrie Partridge, who had previously been the interim legal director, that she thought the mayor and Nick were unhappy with her performance for this very reason, because she wasn't getting these things done in terms of conducting these meetings, the reach out or outreach to the minority and women business community. She said she was afraid that her job was on the line. She confided that. Completely uncontroverted evidence about that. So, going back to your point, Judge Rovner, is there a temporal proximity issue here in terms of the timing? Well, not really, for multiple reasons. One, because as I said, she had no idea what anybody else made at the time she complained about it, so she couldn't have really had any reasonable belief that anyone else was making more than she was. But, also because there was knowledge on her part. If you look at those email exchanges that I mentioned, one about where she wanted to bar a minority contractor whose bid for some work had some technical non-compliance with it, and Mr. Meyer had to write back to her and explain, hey, we're here to bring minority businesses into the community, not bar them. And she was, sort of, for lack of a better term, she's a little officious. I think that's what, when you read her deposition in its entirety, both of them, that's how she comes across. She's
Is there anything in the record about all this having to decorate and shop and?
Well, she says that, but again, you got to put it in the context of what her responsibilities were. Everybody told her. Kim Ryan, the finance director, testified. Carrie Partridge, the former interim legal director, testified that in order to perform the outreach to the minority and women-owned business community, she was going to have to host these meetings. And nobody was going to come to the meetings if there wasn't any food. I mean, even Mr. Partridge said, you know, don't even invite me to a meeting in the legal department. If there's no food, I'm not coming, okay? And so that was all made very clear. So yes, she had to be in charge of that, just as, you know, sometimes I'm in charge of getting food for our CLE programs at my law firm. But that's the same thing. That's what she had to do. There's no contention that she ever asked to be reimbursed for that and was refused. There's no contention that anyone was actually ordering her to do that. I mean, that was just the expectations. If you're going to host a meeting, then you're going to provide food and beverage, or at least make arrangements to make sure it happens. So again, you know, that's getting kind of twisted in terms of how she's, I shouldn't say twisted, but overblown, all right? That she was made to be this chief cook and bottle washer. Anybody who runs a meeting is going to have to do that. I wanted to touch on a couple of things also that came up here. You know, Judge Rovner, you asked about other women employees at the city. There's some very senior people at the city of Rockford. Marcy Leach testified. She's the city engineer in charge of waterworks and things like that. Kim Ryan, another woman in charge of finance. She's the finance director. You know, we go back to this issue about the common job responsibilities that supposedly existed. You know, the plaintiff is basing that argument on the fact that they went to the same meetings, reported to the same person, and worked in the same office, but that's not the legal standard under the Equal Pay Act. It has to be the responsibilities of the job, not the fact that you may have a broad, and that's another thing. I mean, Kim Ryan, the HR person, testified, I'm sorry, yeah, I think she's HR. She testified that senior manager is not really a job category or job title at the city. It's a, you know, you might consider certain people at that level, but that's not the job description. The hostile work environment issue I wanted to talk about briefly. There, you know, the plaintiff cites absolutely no analogous cases. Her entire argument is that, you know, people just ignored her sometimes, seemed to be condescending, didn't pay attention to her, may not have invited her to meetings. There's no case cited in the plaintiff's brief that's even comparable to that. The Patton case that we cited in ours is almost identical, where someone claimed that other folks in the office were standoffish, rude, or ignored them. The court found that that's not a severe and pervasive environment. Beyond that, those were the only notes I had that I wanted to touch on. Judge Reinhardt declined to maintain supplemental jurisdiction over the state law claims. Those survive. You know, the plaintiff can pursue those. I think the judge gave very good reasons for why he didn't want to retain those particular claims, and I don't think there's any real contention that that's a start over. There would be absolutely no reason to redo the depositions in order, you know, for those claims to proceed in a state court. So, unless the court has any specific questions,
Nope.
we would ask that you affirm the judgment.
Hearing none, we thank you very much, and we're going to have Mr. Vincent come up.
Mr. Kramer.
Oh, I'm sorry. Thank you, Mr. Kramer. All of that.
Good morning, Your Honors.
Good
Counsel.
morning.
May it please the court. There are some points that I do want to address that were raised by counsel in response to Mr. Urani's statements. First off, it is important to note the timing. The timeline shows that this alleged event that she was written up for, or was the performance issue, was 9 months before, in October of 2017. There's nothing in the record that shows that was brought to her attention, that she was written up for it, or that her job was on the line. I want the court to look at the emails. There's nothing in those emails that counsel raised that said, listen, you're going to be written up for this, or you're going to be suspended for this, or let alone that you're going to be terminated for it. The only time that she was told she was going to be terminated was because 2 days before, she goes in and says, I'm being treated differently. And oh, by the way, I reported this to the mayor back in 2017, in June of 17. The other thing I want to point out, and I do want to point to Mr. Partridge, the only The only review that was submitted about my client's job performance was a glowing review in May of 2017. Between May of 2017 and June, when she is terminated, there isn't one incident of Mr. Meyer or the mayor coming in and saying, listen, you're not doing your job very well. In fact, we were so upset about what you did 9 months ago, we've now decided that we're going to terminate you for it.
And this goes to this conflict adverse environment where we have imperfect communication, perhaps going back and forth. Is that to be visited on both parties or just the city?
Well, just the city, Judge, because at the end of the day, they're the ones that hold all the cards, right? They're the ones that get to determine if they have a progressive discipline policy, Your Honor. They completely ignored it. They went from 0 to 90 in terminating her in 2 days. And what happened between those 2 days? The only event that happened in those 2 days was that she complained because Mr. Hackinson and Mr. Franzen, they weren't the only difference in the senior manager duties. Listen, the EPA does not require an identical set of job duties and responsibilities. If that was the standard, no female would be able to bring any claim before the district court or this court, because there's never going to be that case. In fact, the case that we cite to in the Fourth Circuit, the McCullough versus Allegheny County case, addresses this specific issue because there were added responsibilities. But those added responsibilities was because she had to decorate. She had to go buy the donuts and go to the grocery store. She had to do her own typing. She had to go before the court or before the meetings, and she had to do all the arrangements. There's nothing on the record that Mr. Hackinson or Mr. Franzen were called upon to do that. There's nothing that are in any emails that counsel cites to that addresses that point. The other thing is that how in the world is an employee supposed to know the exact dollar amount in confidential employment records of what her male counterparts raise? She's basing her information on her observations, her interactions with the people in the department. They're the only comparables. So if we don't have, and I read counsel's brief, and you are good with brief writing. when you write your brief, it makes it seem like we have to have identical set of facts. You're never going to have that. We have senior managers that attend senior manager meetings. They oversee their departments. Those are going to be the only comparables to who she has. And oh, by the way, when you do a comparable fact analysis, it's all over in the case law, including the Seventh Circuit, that it's a very fact-intensive exercise, and that it's rarely should be decided on a summary judgment motion. And that when we do show, and we did show, that she was not making as much money as one of her counterparts, and that there was only one that she was. But interestingly enough, gentlemen, and Your Honor, that what happened was after she was fired, they separated her job into 2 different jobs. And that was also referenced over a year before by Kerry Partridge in his review. He's saying in there at the end, I appreciate the fact that she has been embraced the expansion of her role into overall contract compliance monitoring and envision the need to redefine her job duties in the future. She's going to the mayor in 2017. She's going to Mr. Meyer and the mayor in 2018 saying, listen, I've already brought this up to you. I'm having all these other job duties, including the decorating, including the shopping, including the typists. None of these male comparators, or any male for that matter. And the other thing is that when you look at the testimony, there's a lot of I don't knows and I don't remembers from the key people of the defense, including the supervisor, including the mayor. And oh, by the way, when they're asked questions about the salaries, they didn't even know what the salaries were. So if the mayor and the supervisor had trouble with that information, and you had to go to the HR person for that information, how in the world do you put that onto a plaintiff who's saying, listen, I work with these people in the same building, in the same area. I don't see them doing any of this stuff. I'm having to do it. And oh, by the way, I have these extra contract duties that my supervisor at the time says, we're going to have to look to expand that because your job duties have been expanded past what was set forth on your hiring. That
I'm going to have to ask you to pretty much wrap up.
Okay. Your Honor, I just think, like my colleague Joe Urani had mentioned, there are too many questions of fact, especially, Your Honor, you had asked questions, what's your strongest argument on previous arguments here today? My strongest argument is going to be on the retaliation and on the discrimination. I think it's also very strong, maybe not as strong as on the retaliation and the discrimination, but also on the EPA. But on the retaliation and on the discrimination, they don't have any facts to controvert what our plaintiff is saying happened to her. And neither does the documents. Look at the emails, look at the review, look at the termination letter. The termination letter itself didn't even say or reference the October 2017 meeting that they had this big problem about. I thank you for your time.
Thank you.
Yes, and we thank Mr. Urani, Mr. Kramer, and Mr. Vincent for their time, and the case will be taken under advisement. Great. We're going to go on to case number 4, please. 23-2360, Thad Brockett versus Effingham County. And we're going to get Mr. Meyer in remotely. Let's see. There he is. Hello.
Am I in, Your Honor?
You certainly are.
Thank you very much.
You're welcome, sir. You may begin whenever you're comfortable.
Thank you. May it please the court. I represent the plaintiff appellant, Thad Brockett. We're asking the court to reverse the district court's granting of a motion to dismiss under Rule 12b-6 in this First Amendment retaliatory discharge case. My client, Thad Brockett, was a long time, in fact, 18-year member of the Effingham County Sheriff's Office, was the operations sergeant at the time he lost that job. He complains specifically that he exercised his First Amendment rights as a private citizen in 2 ways. First, there was a dispute between the Sheriff Monette at that time, and the county board and the county board chairman, Jim Neiman, about the operations of the Sheriff's Department. In fact, there were allegations by Chairman Neiman that Sheriff Monette was mismanaging public funds and, in fact, stealing or converting public funds during his tenure as sheriff. My client's, what we believe to be protected speech, was that he took the sheriff's side in these disputes and publicly did so. And we think that that's one of the reasons that the county board and Chairman Neiman retaliated in terms of causing him to lose his employment.
Mr. Meyer, could you
yes,
tell us why you believe the second set of statements that you've charged are not within your client's job responsibilities?
The second set being the reporting of misconduct by subordinate employees?
Correct.
Okay. I have 2 reasons for that. The first one is based upon the case law cited. My client reported that misconduct, which was pretty serious, involving criminal offenses, not only internally to the Sheriff's Department and internally to county law enforcement, meaning the state's attorney, but he also reported it to outside law enforcement agencies, including state police, FBI, and others. And perhaps even more importantly, he voiced those concerns to members of the general public. Now, we rely upon the Christofek case, which is very similar. In that case, as the court knows, it's a Seventh Circuit case. There was a police officer who reported misconduct by a fellow officer, not only internally, but to the FBI. And this court, the Seventh Circuit, held that that was sufficient to make it something that was actionable. In other words, it wasn't part of his job duties to make that report to the FBI. The argument has been made by the defense in this case that a police officer has a duty to report crime wherever and whenever it's appropriate for him to do so. And we think that that does not include members of the general public. They're not going to do anything about prosecuting a criminal offense. And we do allege that it was reported to members of the general public. So we don't think that was part of his job duties. We think, on the other hand, that was part of his freedom of speech as a private citizen to go ahead and report those things to outside agencies and to members of the general public. And I hope, Your Honor, that answers your question.
But how could he have known about the unlawful conduct were it not in his professional capacity?
Well, he certainly found out in conjunction with his professional capacity because the operations sergeant was given supervisory authority over jail personnel. We don't dispute that. That's how he learned about it. He did an investigation of these two individuals.
And isn't it a public employee's duty to report criminal conduct to law enforcement when he sees it in employees that he's supervising?
Yes.
I'm trying to figure out how he could have been speaking as a private citizen.
Well, number one, I would say because he was reporting it to the general public as well as to law enforcement. And we think that takes it out of his general duty, job duty, to report it to law enforcement. And secondly, I think we're missing an important point here, and that is that we do not know within the purview of the procedures of Effingham County, Illinois, what law enforcement agencies it was proper or even advisable for him to make a report. I think that the district judge made inferences in that regard, made inferences against the plaintiff, which is improper. If inferences are to be made that a report should go to A, B, C, or D, those inferences should be made in favor of the plaintiff and not against him. And I hope that answers your question, Your Honor. Perhaps not sufficiently. In any event, shall I go back to point one, which is the...
Wherever you're comfortable, please.
Thank you very much. The first point is that the client, Sergeant Brockett, supported the sheriff in his dispute with Neiman and the county board. In this regard, when I read the district court's opinion, I was, to use the kind word, surprised to see that the district court made a finding that the activity of which the sheriff was charged, stealing public property, misappropriation of public funds, is not a matter of public concern and therefore not protected under the First Amendment. I hasten to say that if we were to ask, and I know we're not going to do that, any citizen of Effingham County, if they thought those issues were a matter of concern to them, there would be a resounding yes. But more importantly, the district court made that finding without any support from the record and without any legal authority whatsoever. So we think that was error. On its face, there was a one-sentence finding that it's not a matter of public concern, it's personal to the plaintiff. And I at least fail to see how that could be arrived at even by some kind of stretch inference. So we think that on both of those points, the district court should be reversed. My client was acting in accordance with his rights under the First Amendment, and his speech was protected contrary to the district court's view of the situation. There are three other issues that have been raised by the defense in this case, and I'll cover them quickly. These issues were not decided by the district court, but they haven't been waived, so I suppose this court could address them. One of them is, or the first one, is the question of color of state law. The easy answer to that is, and I want to back up a second so that the court can be have in the front of your minds just how it is that Thad Brockett lost his job.
You need to watch that clock, Mr. Meyer.
That's all right. I probably won't need more time anyway. He lost his job because the county board, including Jim Neiman, defunded his position as operations sergeant. That's under color of state law. They're state officials. How that could not be under color of state law, I don't know. And I think that drags all their other conduct into the same basket. Secondly, they have a causation argument, which in paragraph 16 and 17 of counts 1 and 2 respectively, we allege that the defendants retaliated against Sergeant Brockett for that speech. That we think under the purview of 12b6 is sufficient allegation to allege causation. And lastly, they argue that we haven't alleged anything to bring this case within Monell insofar as the county board is concerned. And once again, I rely upon the ordinance that was passed that defunded Sergeant Brockett's job. That certainly was an act of the county board, which is the chief legislative body of the county. So that argument must also fail. In conclusion, we ask that the case be reversed and remanded for further proceedings.
Thank you. And I will give you your 2 minutes for rebuttal. Thank you very much. Mr. Drinkwine.
May it please the court and good morning, counsel. Chris Drinkwine on behalf of Effingham County and former board chairman Jim Neiman. In considering whether the plaintiff stated a claim based on his speech in support of Sheriff Monette, the district court recognized that under the Garcetti rule, plaintiff was required to allege that he spoke as a private citizen and that he did so on a matter of public concern. The district court understood that under Connick v. Myers, whether a statement is on a matter of public concern must be determined by its content, form, and context. The district court also understood that under this court's decisions in Kubiak v. City of Chicago and Bivens v. Trent, even if speech concerns a subject of public interest, it does not constitute speech on a matter of public concern if the expression addresses only the personal effect upon the employee. After reiterating these well-established rules, the district court concluded that plaintiff voicing his opinions in support of the sheriff did not rise to a matter of public concern because it pertained to matters personal to the plaintiff. In his first appellate contention, plaintiff attempts to argue that the district court's analysis was incorrect, but he does not present a Rule 28 compliant argument because he fails to explain why the district court's analysis under Garcetti, Connick, Bivens, and Kubiak was incorrect. He doesn't even cite these cases in his brief, much less explain why he believes the district court misapplied them. And so the defendants respectfully contend that the first appellate issue is waived or forfeited. Defendants recognize that forfeiture is a limitation on the parties and not on this Court of Appeals. And if the court deems it necessary to address whether plaintiff plausibly alleged speech on a matter of public concern, the court should conclude that he has not. Plaintiff argues there's no case cited by the district court and no facts alleged to support the the district court's conclusion. But the district court cited the Bivens case and the Kobiak case, holding that speech concerning a subject of public interest is not of public concern if the expression addresses only the personal effect upon the employee. The conversion of public property and mismanagement of public funds concerns a subject of public interest. But plaintiff has not alleged that he spoke on a matter of public concern, because he has alleged that he spoke in support of his patron who gave him his job and with whom his own interests were aligned, such that plaintiff's speech was advancing a purely private interest. The Bivens case makes clear that it's the point of the public employee's speech that matters. Plaintiff's point was not to expose wrongdoing for the benefit of the public. The point of his speech was to explain that Sheriff Monette did not convert public property or mismanage public funds, and he spoke in support of his own private interest, which was aligned with and tethered to Sheriff Monette's interest. But even if this court disagrees with the district court's reasoning on the matter of public concern issue, the court can and should affirm on several alternative grounds supported by the record and argued by the defendant.
Are all those grounds in your brief?
All the grounds in my brief, yes.
When I was a young lawyer, Judge Posner used to say, is there anything that you want to add that's not in your brief? So
Yeah.
start with that. I don't know that there's anything to add that's not in your brief.
Well, I don't know that there is, but I think I can maybe refine some of the alternative grounds and maybe impress upon the court which ones I think are the most important.
I'm just wondering if you need to get there at all.
I see.
But I'll let you do what you want.
I'll go ahead and move to the second form of speech with regard to reporting the misconduct of the correctional officers.
I mean,
to the sheriff.
isn't the plaintiff's argument here along the lines of, even though I learned it during my employment, as long as I tell somebody else who's not in the chain of custody, the First Amendment protects whatever I do, which cannot possibly be the law.
Yes, Your Honor, I think that is his
That's
argument.
it, right? And his first argument is, as long as I make a statement in support of my politically elected boss, I'm protected by the First Amendment. That can't possibly be the law either.
Right, Garcetti and so forth.
Right.
Precludes that. And I think we heard today, and certainly in his brief, he concedes that his internal reporting of the misconduct of the correctional officers is pursuant to his duties and therefore not protected speech. But he tries to draw this external-internal distinction.
But
and
that
it's-
would be impossible, right? I mean,
Right.
anybody would be protected by the First Amendment is to conduct an internal investigation, then call the newspaper, and now I'm protected by the First Amendment. There's no case that supports that
Right.
ever in the history of jurisprudence, right?
I agree, Your Honor.
I do
What
too.
matters is whether the report was the result of his official duties as a supervisory official at the Sheriff's Department as the operations sergeant, and he specifically alleges that in paragraph 4.
Right.
So that's over. Something that's not in my brief that I would like to add, Your Honor, on the same point, and perhaps overkill, but in Hoskins v. Sheehan, which is 549 F. 3rd 480, is instructive on the point that there can't possibly be this internal and external reporting argument. And in that case, a social worker employed by the Cook County Department of Corrections alleged retaliation after she made an internal report that she was assaulted by a corrections officer in the parking lot, and after she reported that assault externally to the Chicago Police Department. This court held that the internal report was official duty speech because she had a duty to report misconduct to her supervisor. But the court held that the external report to the Chicago Police Department was not made pursuant to her official duties because the report was not generated in the normal course of her duties, but rather was similar to a police report filed by citizens every day. So if it was, the court wouldn't have ventured into deciding whether the report was a result of her duties or not, if all there had to be was an external report. And as noted in this case, plaintiff has alleged that his reports concerning the correction officer's misconduct were generated in the normal course of his duties. In fact, they came from his own investigations, 2 of them. His responsibilities as operations specialist required him to report it. So unlike the social worker in Hoskins who made a external report concerning a correctional officer which she had no supervisory authority over, the plaintiff in this case was clearly reporting his own investigation pursuant to his own duties, and that speech was not protected by the First Amendment. I guess I would go into the members of the general public argument as well, and make 2 points. Only well-pled facts must be accepted as true on a 12 motion, and this is a conclusory, threadbare allegation insufficient to satisfy the Twombly-Iqbal plausibility standard. And in any event, and that's because it lacks the when, where, who, or by what means these public reports were made. But moreover, there's no allegation in the complaint that the defendants knew about these purported reports to the general public and statements made to the general public. And the defendants certainly cannot retaliate for speech that they were not aware of. If the panel doesn't have any more questions, I'm through, and we would request that you affirm the judgment of the district court. Thank you.
Thank you, Mr. Drinkwine. Okay, Mr. Meyer, I will give you the 2 minutes you requested.
I just have one comment and to illuminate perhaps how the district court and defense counsel have been drawing inferences that are improper under the standards of 12b-6. The statement is made that the reporting or discussion of the dispute between Sheriff Manette and Neiman about misappropriation of funds is personal to the plaintiff. I ask, where does that come from except by some kind of inference that is drawn against the plaintiff rather than for the plaintiff? They speculate that perhaps my client had a close relationship with Sheriff Manette, and he thought he was going to gain something by perhaps supporting him. That's speculation. If it's an inference, it's drawn the wrong direction. And this case is replete with that kind of violation of the standards under 12b-6. So that's all I have to say. Thank you.
Thank you. I want to thank both Mr. Meyer and Mr. Drinkwine, and of course the case will be taken under advisement. Thank you very much.
Thank you, Your Honor.
All right. Okay, we're going to go on to case number 5, and that is Appeal 23-2525, Economic Loss Plaintiffs versus Abbott Laboratories. And it's Ms. Grombacher, yes?
Yes. Good afternoon, Your Honors. May it please the court. Kylie Grombacher on behalf of the plaintiff appellant. I'm going to endeavor to save 3 minutes for rebuttal. And it is my first time before this court, so I'm honored to be here.
Welcome.
Oh, welcome, welcome.
Thank you.
We're always happy to have, as I mentioned earlier, more customers.
Well, unfortunately, I am here, but I am honored to be here. The case before you presents a simple question of whether a group of plaintiffs have established sufficient constitutional standing under Article 3 to bring various state consumer protection and warranty claims. The district court rightly determined this was a facial, not a factual challenge. And so all of the allegations in the complaint should be taken together and construed in light most favorable to plaintiffs. Here it's alleged that Abbott is one of very few companies that produce, manufacture, and sell infant formula in the United States.
Ms. Grombacher, can I ask you?
You sure can.
What specifically is the plaintiff's injury? I'm going to nail you down here on exactly what the plaintiff's, because your briefs seem to bounce around a little bit. I mean, we started with at risk, and then I think the plaintiff spent about a paragraph talking about the paid a premium, and your whole reply brief is explaining your injury is paid as a paid a premium, which I don't understand, because they got the product they bought.
So I think that's a very fair question. Here, I think what the plaintiffs say they thought they were getting was formula produced at 50% more than the generic price.
And they did. That's exactly what they got. Like, we talk about the Aqua, I forgot what it's called, the Aqua.
Aquadots.
That's different. Plaintiffs bought a defective product. Here, they didn't. They don't even allege that they did.
Well, I think that they do. I mean, I think paragraph 99 of the complaint talks about the consent decree that Abbott entered into. As part of that consent decree, it admitted that the formula there violated federal regulations, and under the CFR, that would deem those products adulterated and illegal for sale. So those products should never have been placed into the stream of commerce.
But look, timing is so important here. Before Abbott announced the recall, the plaintiffs could not have been concerned about the risk because they didn't know about it. As soon as Abbott announced the recall, the plaintiffs knew about the contaminated product. But there was no risk that they were going to use the formula because they were instructed not to use it. And they were offered full refunds. So at what point in time was there a known risk?
Well, I think that the injury here is the fact that they paid for a product that should never have been on the market. And that puts it in more in line with cases like DiBernatis in the 11th Circuit and Franz in the 9th Circuit, where even in those cases, there wasn't an allegation that they failed to perform or that they inflicted physical harm. The injury was that they were illegal to sell, and they should never have been placed into the stream of commerce. Same here. I mean, the plaintiffs paid for a product that should never have, that was illegal, that was adulterated because of the way it was produced. That devalues the product. So the price that they paid at the point of sale, that's a concrete, tangible injury.
Under your theory of injury due to risk, what are the outer limits? If there was a 1 in a billion chance that someone could buy a contaminated product, does every person who ever bought that product have standing to sue?
Well, under our fact pattern, every product is adulterated. Every product came out of these manufacturing processes.
Why were there warnings then, Ms. Grombacher, with regard to certain lots and others?
Well, the class definition goes back further than the immediate time period of the recall. And so throughout that time period, and there are allegations in the complaint, the manufacturing violated federal statutes and regulations. And Abbott agreed in a consent decree. It admitted that was the case. Under the CFR, those products are deemed adulterated. And under 21 USC 331, it's illegal to sell those products. So to us, that's a very cabined in limited injury. This is not going to open the floodgates. I mean, how many times do you have a product the defendant admits is adulterated? And plaintiffs say, well, wait a minute, we paid 50% more because we trusted you and because we thought we got a safe, unadulterated product. I mean, to go back and say, well, it didn't cause physical injury doesn't really explain the injury here. I mean, the injury was safe and unadulterated. Here, it's admittedly adulterated and unsafe to sell, illegal to sell. We think that the district court's analysis expanded the scope beyond standing because here we have what we believe is a direct, traceable injury, concrete financial harm, and it's capable of redress. That's all that standing alleges. We may not win.
You wanted uncontaminated formula, right?
We wanted unadulterated formula. Yes, that's what the allegation is.
And you bought an unadulterated formula, right?
The allegations in the complaint are not that. The allegation is that product produced at the formula, at the Sturgis formula, was not produced, and there are pages and pages of allegations about why it wasn't produced in accordance with the federal regulations. But the federal statutes say under CFR 106 that if they aren't complying with these federal regulations, these products are deemed adulterated. And that at least sets up a plausible injury here for plaintiffs.
Does the deeming overcome the deficiencies in the complaint?
I think the deeming overcomes the fear that this is a speculative injury, or that there is questions about these questions about how many lots are enough or how much needs to be pled. Here, it's every single product that came out is adulterated because it came out of a facility where the regulations were violated.
Is this like a risk contribution theory of liability, or?
It's, well, I mean, we're borrowing specifically directly from the consent decree. I mean, if you admit that you produce in violation of the federal statutes, 21 CFR 106 says those products are deemed adulterated. And if they are deemed adulterated, then they're illegal to sell, and they should never have been in the stream of commerce. Each and every product is subject to that.
Hey.
At least those are the allegations. I mean, the question then is, are these concrete? Is this tangible harm? I think we can all agree monetary harm is very concrete. And is it plausible, or was it speculative? When you start getting into, was there actual physical contaminants in the product, that's where it becomes a little bit more difficult for the plaintiffs, and maybe in cases like Johnson & Johnson, where there wasn't a consent decree and there wasn't an admission that this product was either had illegal ingredients, like in the 11th Circuit, or in this case violated federal regulations. I think it's a lot more difficult. The district court was certainly concerned about a limiting principle here, but this isn't like lettuce that is contaminated, and this is a systemic pattern of manufacturing that's in violation of the federal rules, and an admission by the defendant that it's done that.
Okay.
I'm going to reserve the rest of my time. Thank you.
Okay, we're going to give you your 3 minutes.
Okay.
All right, Mr. O'Quinn.
Thank you, Judge Rovner. May it please the court, John O'Quinn on behalf of Abbott. We're hearing some very new arguments here at the podium for the first time. We're hearing new arguments on appeal, new arguments at the podium. I want to level set and correct my colleague on a key point. There is no admission in the consent decree that Abbott sold adulterated foods. That's not in the consent decree. It's not in their complaint. The only thing that is...
That would be a weird thing to admit.
That would be a weird thing to admit. And of course, Judge Kirsch, adulteration is a legal conclusion. It's not a factual issue. So, sort of set that aside as well. But the allegation in their complaint is simply that the consent order recites what the underlying complaint alleged. That's paragraph 99 of the plaintiff's complaint. It's at SA 33. So there is no admission, and their analogy to de Bernadette, the 11th Circuit case, completely crumbles. Even if the 11th Circuit case was applicable, and it is not, it would be immediately distinguishable for 2 reasons. Number one, as the panel itself in de Bernadette recognized, it addressed a very special, limited circumstance. The specific circumstances limited to where, quote, Congress had affirmatively banned from sale those types of ingredients. In other words, the transactions were void ab initio. It's not that there was an ex post determination that there may have been a problem with them, and there has been no such ex post determination here. An FDA Form 483 is not a final determination by the agency, and again, the consent decree simply references allegations, not any findings. Second, the more analogous cases here, of course, are the Myers-Armstrong case, which was affirmed by the Ninth Circuit, as well as the Rivera case in the Fifth Circuit. Under plaintiff's rationale, those would have come out the opposite way. That is under the rationale that the plaintiffs are articulating now here at the podium. But to take a step back, I think it's important to understand the sweep of the plaintiff's theory. Anyone who has ever eaten in a restaurant that is subsequently alleged not to have been up to sanitation code, even if the individual meal that they received was completely unaffected by that, and they did not get sick, and they did not face a future risk of getting sick, that person would be injured. The same would be true for anyone who ever ate groceries that were recalled because they didn't allegedly follow various procedures, even though it is not alleged that it affected that particular grocery item that the person bought, would be injured. And in fact, if you take their theory to its logical, or I submit illogical conclusion, anyone who has ever rented an apartment or bought tickets to the theater or flown in a plane or ridden on a bus or a train would be injured if those venues or vehicles were subsequently alleged to have been unsafe because they were at risk of having a defect. Not even that they had a defect that didn't affect them, but they were simply at risk of having a defect. And that is the gravamen of the plaintiff's complaint here is that that they did not get a safe product. If you look at their allegations, they refer to safety over and over and over again. But we know that the plaintiffs did get what they paid for because they do not allege that the cans, the units that they purchased were not safe, were not effective, were not able to be used for the purpose for which they were intended. In other words, as nutritious, nourishing food. In fact, just to be clear about this, they do not allege that the units they specifically bought themselves posed any risk. Their maneuver here is to uplevel this and to say, well, there's a risk that the can could have been contaminated. That is not sufficient under the case law, and if this court were to hold that, it would create a circuit split with the 10th and the 8th circuits. It would, in the Renfro and the Wallace cases, they couldn't be any clearer. That, as Renfro said at page 1305, quote, plaintiff could not have suffered any consumer protection injury if they had not purchased food containing the objectionable ingredients, end quote. It's not simply enough. Renfro rejected the idea that you just need to allege there's a risk that the food, that the units you purchased might have been contaminated. You need to allege that the units that you purchased were in fact contaminated. And that's what's missing here, that there was something, no allegation that there's something wrong with the particular units, the particular product they themselves actually purchased. And what that means here is that all roads lead back to whether or not the product itself that the plaintiffs bought was allegedly contaminated or unsafe. They don't allege that. What they alleged that they bargained for was safe, nourishing food. And as Judge Cannelli put it, these plaintiffs received safe, nourishing food. Their theory posits a hypothetical problem that did not really affect these particular plaintiffs. Again, not because no one got sick, which they didn't. They're their own allegations. They didn't, and that is evidence that these were not contaminated, but because they do not even allege that the units that they themselves purchased were defective, nor plausibly can they. I'm happy to answer any questions that the court may have on this. The only other point that I would make, if the court has no further questions on this, is that I think this court's relatively recent decision in the Dinerstein case is directly on point, and I think it is ultimately dispositive of the issues here for reasons, frankly, analogous to those that the Renfro and the Wallace court identified. This court at page 515 said, quote, a plaintiff seeking money damages has standing to sue in federal court only for harms that have in fact materialized, end quote. And this risk that something in the manufacturing process could have affected particular units certainly did not materialize as to these plaintiffs. They have conceded that by their own allegations, and what they are left with is the kind of breach-only theory that Dinerstein found to be insufficient to create standing. If the court has no questions, I'll yield back the balance of my time.
Thank you, Mr.
Thank you
O'Quinn.
very much, Mr. O'Quinn.
Thank you, Judge Riddle.
Okay, Ms. Grombacher.
Thank you. I appreciate the rebuttal time. I'll be quick. I do think that the consent decree is an important fact here. And whether there's no admission, whether they just simply admitted that the complaint states a claim, these statutes are in there. And if true, I believe they plausibly give plaintiffs a path to at least an injury that they have standing to challenge for warranty claims, for consumer protection claims.
So, Ms.
Otherwise,
Grombacher, you're, just to characterize the position, and correct me if I'm wrong, if plaintiffs purchased formula that was manufactured at the Sturgis plant during a certain time frame, that would be enough for the plaintiffs to have pleaded financial injury.
yes, given that the allegation is that manufacturing did not comply with the statutes and are deemed adulterated. So they would not.
I'm over here. That's okay. What would we do with a situation like a restaurant, for instance? This happens all the time. A restaurant gets shut down temporarily for health violations. Would everybody who ate in the restaurant, even though they didn't get sick, they got exactly what they paid for, be able to file a lawsuit against the restaurant because the restaurant was not somehow up to the town's code for a particular period of time?
Yeah, that's the analogy that's thrown around a lot, and I think perhaps part of this too is the representations made by the defendant that they're an industry leader, and that they paid 50% more. So to me, it's more like trying to order a piece of yellowtail sashimi from Nobu or some really fancy restaurant, and my DoorDash driver says, God, that's the other side of town. I'm just going to grab this gas station piece of sashimi yellowtail and I'm going to bring it to you. And I eat it and I don't get sick, but I realize later, well, that's not what I paid 50% more for. That's not, I was relying on a reputation. I was relying on something else.
But that's not what you bought. I mean, that's not what you paid the Uber driver for, presumably.
Right. I paid for a more expensive product that I thought was subject to different processes. That's the same here. I mean, I thought I was...
Well, that would just be fraud.
It would, and I think this is fraud. I mean, I think when a company knows that it's violating federal regulations and that those violations deem the product adulterated and they continue to sell it, even though it would be illegal, and they charge me 50% more than the generic, I think that's fraud. I think that should never be in the stream of commerce. I think I overpaid. There's some, even if it's a penny, more than I would have ever done at the point of sale.
But I guess I'm looking at paragraph 99 of your complaint, and I don't see here an allegation that all of the products that were produced in Sturgis were adulterated.
I think that the complaint taken as a whole that details all of the failings, the systemic failures, which are actually detailed kind of in the codes and the CFRs that are cited in 99, put that together. If it's not clear that that was something alleged by the plaintiffs, we can certainly send it back and let the district court take a look at it. Because if that allegation isn't in the complaint and that's not something we're dealing with here, then, and it's something that could confer standing, we think we should have the chance to at least have the court look at it rather than slam the door shut to these plaintiffs. And I think that to not take up any more time. Thank you all.
Thank you very much. Thank you, Ms. Grombacher. Thank you, Mr. O'Quinn. Case will be taken under advisement. Now, case number 6-232196, United States versus Yarmel Austin, has been submitted on the briefs. And because of that, we will say adieu and thank everyone. And the court will be in session again tomorrow, but at 11 o'clock. All right. Thank you all very, very much. And